the morning show here on HRISE News. At this point, we'll move on to that promised conversation around the economy, starting with last week's reprieve for Nigeria in its long-running legal battle with Process and Industrial Development Limited. We'll also devote some time looking at the federal government's crusade against corruption, economic sabotage, and other issues of national interest. And joining us now from our HRISE Abuja studio to help us focus on all of these issues is Abubakar Malami, Senior Advocate of Nigeria, Minister of Justice, and Attorney General of the Federation. AGF, good morning and welcome to the program. AGF Malami, good morning and welcome to the program. Yes, well, two quick questions so that we can provide a context. Yes, thank you. On Friday, September 4, the court of Ross Cranston J ruled in favor of Nigeria in the matter with P&ID. Many analysts have said this amounts to a victory for Nigeria. How much of a victory is it, considering that what we've been able to get is a reprieve and a relief? And in responding to that ruling, you've also been quoted as saying that heads will roll because too many local officials compromise unnecessarily. Now, some names have been mentioned, but as the AGF, you will know those heads that will roll. Would you like to share with us some of those names and what exactly went wrong in the P&ID matter?
Well, talking from the perspectives of the victory, I maintain that it is indeed a victory worthy of celebration. But for the purpose of putting the victory in proper perspectives, for proper appreciation by Nigerians, I think you have to look at it from the point of the implications of what could have happened if such victory was not indeed achieved. First, looking at the volume and the size of the arbitral award, it is an arbitral award that amounts to around $10 billion US. And then looking at it from the point of implication, the fact that if indeed such victory and some other victories that predates that of 4th September were not recorded, it could have amounted to perhaps an attack on the national assets of the Nigerian state, both locally and otherwise. Looking at it further from the implication of such victory on our attachment on our national budget, it is indeed in volume and size an amount that could have been enough to address our national budget as it relates to health and education combined together. Looking at it from the further implication, it is an implication that perhaps could translate to an attachment of commercial assets and perhaps maybe inclusive of the National Reserve. And the total implication of this is an outright negative effect and an outright affection to our financial standing locally and internationally, and will certainly affect our economy that is fragile, taking into consideration the prevailing financial situation internationally. So from the perspectives of implication, I think you can imagine the implication taking into consideration the volume of which translates to about 1/3 of our national budget, the volume of which will certainly and definitely affect our educational and health sector to the extent that we cannot have anything left to address our educational sector, to address our health sector at a time. An implication that will have an unimaginable negative effect on our economy and financial standing internationally. Now, taking into consideration the other aspect of your question, which has to do with heads rolling, well, I think heads have started rolling already, taking into consideration that extensive investigation as to the genesis and circumstances of the procedural and associated compromises, procedural and processes compromises along the way, heads have started rolling against the background of the fact that certain elements were already charged to court. Heads have started rolling, taking into consideration that certain convictions have been recorded arising from misgivings associated with P&ID contractual saga. And indeed, heads will continue to roll, taking into consideration that investigations are still ongoing and not in any way abated.
But AGF, how strong is the evidential threshold, considering that, look, these are criminal allegations about persons? How confident are you that, you know...
Well, I think the strength of the associated allegations can best be seen from the dual pronouncement, a conviction recorded as it relates to the Nigerian component of the cases that were initiated, criminal cases that were initiated, and then a civil pronouncement to the effect that it is indeed afferent, and the commercial court in UK agreed with our presentation that there are reasonable grounds for suspicion of commission of offenses relating to corruption and indeed fraud. So I think the combined effect of the two, the combined effect of comprehensive investigations that led to arraignment, to charge and conviction in the Nigerian component of the case, and then the civil component by which we succeeded in an unprecedented manner in establishing a case before criminal court, a case that earns us victory as a nation, a victory to the, in the sense that a victory in the sense that we were accorded an opportunity for extension of time on the strength and weight of the evidence presented relating to fraud and corruption. So the combined effect of this is indeed, goes indeed to establish a point that indeed there are reasonable, not only reasonable grounds, but substantial and I think strong grounds that could, at the end of the day, that have already established a criminal case of corruption, fraud, and associated infractions, and then indeed that has further been consolidated by a civil pronouncement of a UK commercial court to the effect that there are reasonable grounds for not only suspicion, but establishing in effect that a case of fraud and corruption could be established.
Well, thank you, Minister. I would like to say congratulations. I think they're in order. For some people, this may be the first win, but if you put it into perspective, it's about the third or fourth so far in the pursuance of this case. And I'd like us to touch back on a background and lessons learned, if any. This was a case inherited by the Buhari-led administration, but we do understand that there was consideration for settlement. Tell us why that was a consideration. When you look at the case, it was not subjected to procedural rigor, requisites. Organs of government were not even, signing off on this contract in the first instance. So why was the government willing to settle initially? And let me also ask you, what are the lessons we have learned to ensure that there are no other PIDs, and what are you doing really?
Well, within the context of perhaps possibilities that were considered for settlement, as you rightly know, government operates in continuity. And the settlement aspect was something that was inherited by the government, by this government under the leadership of President Muhammadu Buhari. At the time we came in on board, we found an existing position. The government had indeed offered to P&ID an amount within the region of over $800 million, which offer was turned down by P&ID, which was claiming around over 6 billion naira through the arbitral proceeding. Notwithstanding the continuity principles on the basis of which the government is expected to operate, we found that element of the offer being excessive, being unreasonable, and being baseless against the background of perhaps limited appreciation of the prevailing facts and circumstances. And we felt, even if we are indeed submitting to the principles of continuity of government, there is need as well to perhaps unravel the existing undertones, which to our mind left much to be desired within the context of transparency and accountability. And that is how eventually, at the end of the day, our decision to save the nation of perhaps advancing the sum of over $800 million that was rejected by P&ID, we felt it could have an extraordinary negative effect on our economy. And taking into consideration the prima facie evidence of perhaps possible compromises, there was need for us to have a second look of the entire process. And unfortunately, looking through the entire processes, it came to light that there were a lot of misgivings, a lot of compromises, a lot of perhaps apparent collusion, criminal conspiracy that could be imputed, that could be insinuated, arising from the conduct of the principal characters involved therein. And I think that our conclusion was not out of place, taking into consideration the procedural and processes breaches associated with the conduct of the parties. Take, for example, a ministry that is saddled with development of policy, now coming in to sign a contract and committing the federal government to an agreement of around that runs into billions of dollars in volume, without allowing the necessary procedural steps to be taken. What are the procedures, for example? P&ID offered to put in place a gas plant in Calabar for the purpose of receiving gas from ExxonMobil and ADEX, among others, wet gas, and processing the same to lean gas for the purpose of power, energizing perhaps the power projects in the country. So that logically and in essence and by implication places you on an assumption that the starting point for P&ID is to acquire a land on which the project is expected to be constructed. So the question is whether there exists such land or whether such land was acquired by Process and ID. My answer is it wasn't at all. There wasn't any evidence of land acquisition on the basis of which the facility ought to have been placed. Now, if indeed it was a project that right from the onset was expected to be executed, or perhaps the parties had a clean heart and mind to establish, it is equally only logical that those agencies of government that are responsible for the grant of associated permits, for example, talking of the Department of Petroleum Resources, there ought to have been presented before the department a feasibility study, a geological survey, and associated seismic data establishing the possibility of having that facility on the ground. It may interest you to note that no such feasibility was presented before the DPR. No approvals and permits associated with the generated geological surveys were presented, considered, approved, and permit granted. And then as well, you are talking of a third-party company that was expected to provide the link gas. In these circumstances, you are talking of ADEX and ExxonMobil. So that by implication requires the accommodation of ExxonMobil, the accommodation of ADEX as being parties to a contractual agreement, which in essence requires having in place a tripartite agreement involving the Federal Ministry of Petroleum Affairs, involving the ADEX and ADEX and Exxon on the other hand, and indeed P&ID. So the point of interest here is this contract was executed exclusively between P&ID and Ministry of Petroleum Resources. The third party that was expected to provide the gas, taking into consideration that Ministry of Petroleum Resources do not have one, was never factored into consideration either by way of sideline negotiations, much less of being a party to the contract. So in essence, you cannot have lean gas right from the onset. Those contractual arrangements that will see to a commitment for the provision of the lean gas by ADAX and the ExxonMobil were not taken into consideration. So if you are now signing a contract in respect of an item, in respect of a subject, in respect of a commodity that you do not have, how then on earth can you eventually provide what you do not have? Federal Ministry of Petroleum Resources do not have the gas. The gas is ADAX and ExxonMobil that naturally should have the gas and should be the ones to supply it. And then yet, Ministry of Petroleum Resources and ADAX have negotiated, concluded and consummated and executed an agreement that translates, that requires the provision of lean gas by a third party, and the third party was never ever factored into consideration, was never ever accommodated into negotiations, was never ever made a party to the contract, and then yet you expect the execution of that contract. So, and yet, the agreement should naturally, is such an agreement that should naturally be vetted by the Office of the Attorney General, which office is saddled with the responsibility and professionalism and skill and expertise to look into this agreement and ensure at the end of the day.
Okay. If you can hear me, AG. Okay. We'll just try to connect to Abubakar Malami, Senior Advocate Nigeria Ministry of Justice and AGF, Attorney General of the Federation. We're still talking about the P&ID case, and it's still, shedding more light as regards that. So we've got more questions here, for him as regards the case and what is going on. All right, we'll go for a quick break. We'll be right back. I will talk to Attorney General.
Welcome back to the morning show here on the HRISE News Channel. We've been having a very interesting and illuminating conversation with Abubakar Malami, SAN, the Minister of Justice and Attorney General of the Federation, around issues relating to Nigeria's case with the P&ID in London, a arbitral award of $9.6 billion, and with the Nigerian government saying, no, we cannot pay this amount because that PSGA contract was a product of fraud and a lot of local compromises. And in any case, Abubakar Malami SAN, AGF, has been able this morning first to define the ruling on Friday, September 4 by Justice Ross Cranston as victory for Nigeria. We got relief from sanctions. We also got an opportunity to have more time to properly file our case that, that transaction was illegal and totally against public interest and an abuse of the sovereignty of Nigeria. He has also explained what the local compromises have been. And we were just at the point at getting what lessons Nigeria may have learned and how we could prevent this. Thank you for staying with us. I know today is a busy day for you. You have FEC meeting. All right. But we'll try to get this done as quickly as possible.
So I quickly just want to make this point, sir. Thank you so much for your time and congratulations on the victory. Congratulations to us as Nigerians, I should say. Most importantly, I want to know about the steps taken thus far. We had lawyers in there. We had a case of Shukwashashiri. In fact, Shukwashashiri issued a statement, a strong rebuttal, that there was no way or form he had tried, not to treat the case the way it should be treated. And the case was transferred from Shukbo. What lessons could we have learned from that, since we had people that were on that case prior to that time? And secondly, like I was saying, apart from P&ID now, there are other cases on ground as regards arbitration. In fact, you talked about one that is also brewing, the Eurasia-Sapele deal. Can you just, furnish us with that and things like that? Because will Nigeria keep going for arbitrations here and there? These things are not cheap. Try to settle this matter. These things are not cheap. We're necking deep, close to $200 million to even stall this P&ID process.
Well, the greatest lesson, I think, we need to learn, arising from the P&ID saga, one, to understand clearly that a culture of impunity, a culture of compromises, and indeed a culture of breaches in processes and procedure has long been established and has long been rooted in Nigerian context, in Nigerian situation, and in governance structure of Nigeria before coming on board of this government under the leadership of President Muhammadu Buhari. A further lesson that needs to be learned is the fact that under the leadership of President Muhammadu Buhari, a new culture has already evolved. And the greatest lesson arising from that culture is that there is no room for impunity, there is no room for compromises, and there is no room for breaches in processes and procedure. But the major lesson that I think needs to be learned from the culture of impunity that has prevailed before coming in place of the government of President Muhammadu Buhari was the fact that the collaboration necessary and required in governance was in most cases deliberately and consciously sidestepped out of desire to achieve the compromises that were prevalent in the system. Take, for example, a situation whereby a Ministry of Petroleum is involved in a contract. It doesn't have the required skill to bid the contract and ensure the interest of the government is adequately protected. It's now signing an agreement without allowing for the desired and necessary collaboration to prevail in their conduct and in the art of execution of agreement. It is a clear lesson of impunity. It is a clear lesson of compromise, a compromise that is indeed intended to change the nation and in essence not allow other components of government to do the needful in terms of providing the necessary support to ensure the interest of the government is adequately protected. So in essence, the greater lesson is to the effect that there were impunity, and the era of impunity has substantially, sizably, and indeed effectively been displaced by the administration of President Muhammadu Buhari. A system that allows the lean resources of the nation to be compromised, lean resources of the nation to be, in essence, perhaps taken away for the purpose of addressing a sham contract, a contract that was rooted in fraud, a contract that was rooted in corruption, a contract that is rooted in compromises in processes and procedure is no longer the case. And the further lesson is that the government has resolved to ensure at the end of the day that there are consequences for wrongdoing, and that in effect is what translated into the extensive investigation of the undertone compromises, undertone criminal conspiracies, undertone corruption and fraud that set into the whole P&ID saga, and ensure at the end of the day that people are charged and people are prosecuted. So it's for us now, the lesson is for us to understand that there were a lot of such other contracts that were indeed signed by previous administrations that were in no way intended to be executed right from the onset. And then that culture of impunity as it is today has effectively been checkmated by the administration of President Muhammadu Buhari by ensuring at the end of the day, one, that the interest of the nation as it relates to the commercial and economic aspect of it is adequately prevented. The public interest is now reigns supreme as against the greedy, as against the greed interest of the few. And then two, that the government is set to do whatever it needs to do, whatever it has to do to ensure the protection of the public interest, to ensure at the end of the day there are consequences for wrongdoing.
Well, let's move on. Still on the PID, is there still the possibility of an out-of-court settlement with P&ID? Because there was some talk about the proposal of the Nigerian government to settle out of court. Well, which administration? Is it the Buhari administration that is talking about out-of-court settlement, and is that possibility still on the table? And then talking about other cases which you alluded to, I'm sure many people who are listening to you would like to know what the update is with regard to other cases of arbitration involving contracts and disagreements. One, the Global Steel Holdings. That's Ajaokuta. Where are we with that? And then the Mambila Hydro Project involving HRISE. There was some talk also about settlement out of court. Where are we with those two other cases?
Well, generally speaking, when it comes to judicial proceedings or perhaps arbitral proceedings for that matter, one cannot rule wholeheartedly and a kind of, with clear finality, conclude that there should not be any room perhaps for the possibility of settlement. The settlement is indeed an attribute of arbitral and judicial proceedings, so you cannot rule out the possibility. But then where fraud, corruption, material misrepresentation, compromises on processes and procedures are an issue, I wonder at what point you can now submit to the settlement arrangement, taking into consideration what responsibility we have as a nation of sustaining and upholding the public interest. So in as much as I cannot rule out the possibility of settlement being a natural attribute of arbitral and indeed judicial proceeding, but the fact remains that where fraud, corruption, criminality, criminal conspiracy, material misrepresentation are concerned, it is indeed a tall order.
Yes, but I asked about Global Steel and Sunrise, those two other cases involving arbitration.
Well, I think my answer is general. So we have not indeed closed the door as it relates the possibilities of settlement. And for example, in respect of these two you are talking about, there have been some level of engagement that are intensive and ongoing, out of desire of the Nigerian state to promote its public interest. The public interest, for example, relating to Ajaokuta is the interest of having some level of self-sufficiency in steel production. The interest relating to smelter company as well has some level of public interest. And within the context of the public interest, looking at it, juxtaposing it with some other considerations, you have to weigh your against to see and form an opinion as to which option is the best. Is it the option of perhaps settlement? And if indeed the public interest supports the settlement arrangement, you go for it. So in essence, the Nigerian government, with particular reference to Ajaokuta and Smelter Company, have not foreclosed the possibility of settlement, and the settlement consideration, inclusive of Mambila, the settlement consideration are indeed on table, but then the fact remains that as a government, our major consideration is the public and indeed the national interest. And in the act of negotiations, in the act of settlement, there is nothing that can make us compromise on the public interest and the national interest. So our major consideration is not the settlement in its own right, but of holding the public and the national interest, and nothing will make us shift from that policy that is indeed established, a policy that is indeed upheld by the administration of President Muhammadu Buhari.
Well, a lot has been said about, those who played critical roles in the success we have achieved. However, Minister, I'd like to move attention to what has been playing out in the Economic and Financial Crimes Commission, the EFCC. A lot has been said about yourself and your office, the roles you are playing in that. What are your general thoughts before we go to the specific? What do you have to say to critics who say, for instance, you're scheming for more powers to control the EFCC? The allegations made by the embattled chairman of the commission himself, Mr. Magu, who says you as well should be investigated.
Well, I think the function of investigation is indeed is a function of a factual situation, facts on the ground. And I think no one in the system is above investigation, provided you do not enjoy constitutional immunity. But the fact remains that this indeed, the whole P&ID matter is indeed a collective responsibility. It is, and the successes associated with it is a function of collaboration among the agencies of government, and then within the context of collaboration, those misgivings that are identified, if there are individuals or perhaps institutions that were found wanting, then certainly the government will do the needful, both in point of investigation, both in point of perhaps prosecution, and in point of taking the necessary steps arising from the lessons learned. So if indeed the Office of the Attorney General or the personality of the Attorney General Abubakar Malami is called to question, it is only natural to investigate. And I think neither the Office of the Attorney General nor Abubakar Malami enjoys any immunity arising therefrom. And if by any stretch of imagination along the line, certain breaches, certain compromises, both in terms of process and procedure, are now perhaps have manifested arising from the conduct of the Office of the Attorney General or Abubakar Malami as a person as it relates to the arbitral proceedings, I think it is only natural that there should be investigation. So neither the Office of the Attorney General nor Abubakar Malami claim exclusivity as far as investigation is concerned. So if there are reasonable grounds, if there are serious grounds for suspicion of an offense, suspicion of compromises, criminal conspiracy, or associated things associated with P&ID, I think it is only natural, against the background of the position of the government of President Muhammadu Buhari, to ensure at the end of the day that no stone is left unturned as far as compromises that will injuriously affect the national interests are concerned. I think it is not out of place to consider the investigation if there are reasonable grounds for so doing.
Right. Thank you so much for that insight. There have been calls that you should testify, at the Ayosalami panel. Is this something that once you're called upon, you will go for? And secondly, I want to talk about the state of the rule of law, in Nigeria. There's been lots and lots of talk, court orders and the likes. I mean, the government not, obeying the rule of law in this country. At this point in time, what's your take on those two questions? At first, Ayosalami panel, testifying or bearing witness, to the, allegations against Ibrahim Magu.
Within the context of the rule of law, as you clearly stated, I have a responsibility as the Chief Law Officer of the Federation, as the Attorney General of the Federation, and the Minister of Justice to assist whatever investigation is ongoing locally and internationally. For your information, I have signed and indeed executed over around 8 witness statements before the Commercial Court in UK, which witness statements translated to the victory we are seeing today. So the idea of testimony, the idea of afference of the Office of the Attorney General, and indeed with particular reference to Abubakar Malami, before any panel, before any tribunal, local and international, for the purpose of supporting an investigation that will now see to the establishment and unraveling the truths associated with an issue under consideration is not new, and I will in no way exercise any restraints as far as honoring an invitation for the purpose of supporting any inquiry, any investigation is concerned. So if indeed the Ayosalami panels invite Abubakar Malami as a person, or the Attorney General of the Federation in the person of Abubakar Malami for any testimony, for any clarification, for any examination or cross-examination for that matter, Abubakar Malami will wholeheartedly, gladly, within the spirit and context of the rule of law, be there to testify, be there to be cross-examined, be there to examine within the context of the rule of law. Our position as a government is to be submissive to the rule of law, and the rule of law component of it requires that when we are called upon to clarify issues, when we are called upon to be examined, when we are called upon to be cross-examined, Abubakar Malami will wholeheartedly be there and gladly cooperate with the inquiring institution. And that indeed was an attribute of the government that translates into what victory we are seeing today arising from P&ID. Abubakar Malami has along the line, has within the chain of the arbitral process, submitted to uncountable invitations, responded to uncountable requests for clarification of issues, and indeed executed uncountable witness statements for the purpose of putting the record straight. And the case of Salami will certainly not be an exception. If Abubakar Malami is invited in person, or perhaps Abubakar Malami, as the Attorney General of the Federation, is invited, Abubakar Malami will gladly, wholeheartedly be there to support existing inquiry.
Well, AGF, I'd like to rephrase the question on the rule of law and put it like this. You are the Chief Law Officer of the Federation, perhaps the only minister of the Federation that is expressly mentioned in the Constitution of Nigeria. And many people would like to know, what does the rule of law mean to you? Because one of the major criticisms is that under your watch, Nigeria has not been respecting court orders. It was also under your watch that we had that controversy about national interest being more important than the rule of law, the interpretation of which is quite varied. So the main question is, what does the rule of law mean to you as the Chief Law Officer of the Federation? And will you say that under your watch, you have done enough to defend the rule of law? And then the other part about the suspended chairman of the EFCC, his counsel, Wahab Shitu, says that rather than your allegations about corruption and insubordination, that indeed the victory in the P&ID case as defined is a confirmation that Chairman Magu did very well, and that he was the one in the driver's seat to bring Nigeria to this point. What's your response to that?
Well, let me start by addressing the first question. That is, what does the rule of law mean to me? I want to give a general response to it as to what constitutes a rule of law. A rule of law is operating within the context of the law, taking into consideration the prevailing rights available within the law and enforcing them, taking into consideration the prevailing rights available to personalities, individuals, as enshrined constitutionally or by legislation. So in essence, a rule of law is about compliance. A rule of law is about upholding the tenets, the constitutional, the tenets of constitutional requirements, the constitutionally established rights, upholding them and ensuring that they indeed prevail. So for you to put the rule of law in proper context, understand what the rule of law means and how it operates, you now have to situate it, look at it, assess it, x-ray it within the context of the legislative, within the context of the Constitution and prevailing legislations. So now, what are the constitutional provisions? What are the legislative provisions as far as compliance with court orders, court judgments are concerned? One, for example, if you are talking of a judgment of a court of law, a judgment, for example, is passed against the interest of the government. What are the remedies available to the government? Take, for example, a simple case of bail application. Someone is charged with treason before a court of law, and he files an application for bail, and the court of law granted him an application for bail. So what is the rule of law element associated with that application, both on the part of the government and on the part of the accused? On the part of the accused, the rule of law component is that he has been granted bail and he is entitled to bail. On the part of the government, the rule of law component is if the government is aggrieved, not happy, unsatisfied with the order for bail granted, is one, to consider the possibility of appealing the order, to consider the possibility of filing an application to set aside the bail that has been granted, if it is indeed within the context of the law, there are grounds that justify the application for setting aside of the order. Three, to consider the possibility of staying the execution of the order if indeed an appeal has been lodged by the government. So within the context of the rule of law, if the government decides to appeal and file an application for stay of execution, if the government decides to file an application for setting aside, both the government and the accused are operating within the context of the rule of law, and the way the judicial processes and system operates is not for the government to hook, line, and sinker and unconditionally comply with a court order where it has a constitutional and legislative powers to appeal and file an application of stay execution. So where the government decides not to release the accused on the ground that it has filed an application for stay of, it has filed an appeal and filed an application for stay of execution, and the application for stay of execution is being considered and determined by the court, you are still operating within the context of the rule of law, because the rule of law that gives them an opportunity to apply for bail is the same rule of law that gives the government an opportunity to now do what? To challenge the order by way of an appeal, by way of stay of execution, or by way of setting aside. So it is the act of submission to the court and not resorting to self-help that constitute the rule of law component in general situation. So rule of law is not a one-way traffic arrangement, but indeed a two-lane traffic arrangement where you have to consider the interest of the accused, for example, in criminal cases, and the interest of the government. What are the interests that are provided? Are the two operating within the context and spirit of law, or they are resorting to self-help? Provided you do not resort to self-help, then you are indeed, if you apply for an exercise of right or privilege, you are indeed operating within the context of the rule of law. It's never a one-sided, one-way traffic affair whereby you look at it from the perspectives of complying with an order or a judgment, hook, line, and sinker, without factoring the associated and counter the rights and privileges available at the expense of the other. So that is rule of law for you, and that is the constitutional context of the rule of law, if you indeed care to appreciate it logically, reasonably, and within the context of the Constitution. Now, perhaps the other component of it that you were, let me try to remember this.
No, what Wahab Shitu said about Ibrahim Magu. Wahab Shitu, counsel to Ibrahim Magu, saying that the P&ID, the victory we secured on Friday, September 4, that in fact the person to be given credit for that is his client, Ibrahim Magu, who oversaw the processes of the investigation, the interface with Interpol, and the evidence that Nigeria is depending upon. Contrary to your submission that Ibrahim Magu is guilty of corruption and insubordination. He made that statement, and I wanted your opinion on it.
Well, I think the proper perspectives from which you have to look at the success arising from P&ID, generally speaking, is the perspectives of institution. I wonder how one personality can claim a victory associated with an institution. The Office of the Attorney General, perhaps, that has indeed developed over 6 witness statements in support of a case that led to the victory. Abubakar Malami can never, in law and in logic, personalize the victory simply on account of the fact that he has, in fact, deposed to multiple witness statements that led to it. If, for example, the police played a part as well, and IG, in his own personality as a person, has not come out to claim exclusive victory over it, even though the office of the Inspector of Police played a key role. Again, the Minister of Information and Culture played an extraordinary vital role in perhaps putting across the Nigerian case in local and international public space. And the Minister of Lai Mohammed, His Excellency, Honorable Minister Lai Mohammed, has not claimed exclusive victory. Ministry of Foreign Affairs, for example, as well, provided the Secretariat services, coordinated the necessary processes in UK that supported us and assisted us in putting our case across comprehensively and effectively. The Ministry of Foreign Affairs is not claiming, the Minister of Foreign Affairs, Geoffrey Onyema, is not claiming exclusive victory. So I wonder where a personalized claim to victory can fit into the circumstances of a collaborative support, collaborative approach. For information as well, the Ministry of Finance was equally there. Governor of the central bank was equally played a key role out of desire to ensure that their foreign reserve, their commercial assets, locally and internationally, were not attached. And the governor of the central bank, Emefiele, is not claiming exclusive victory arising from P&ID. So I wonder where an individual personal or personality interest can fit into a process that was institutional, a process that was intergovernmental, and a result of which is indeed a collective effort, a result of which was collaborative effort. My answer is clear that there is no room for institutional, for personalized claim, but then the room that exists is an institutional room for collaboration, and the product, the result, the victory was indeed a collaborative and not individual effort. Thank you.
Minister, what is the future of the EFCC? Because all of the chairmen of the institution have had to leave unceremoniously, and that's including what we're seeing playing out at the moment. What would be the right reforms for the EFCC in your own opinion? And let me ask you, just yesterday, the ministerial retreat was concluded, and the president charged cabinet members, including yourself, to be alive to responsibilities. And this is around the issue of the rule of law in Nigeria and the international picture it paints the country in. Is it going to be business as usual? Because you've tried to describe rule of law and what it means to you, but other people feel otherwise, that, you know, the country is not being put in good light under this administration when it comes to rule of law. So will it really be business as usual, or should we expect reforms?
Our understanding of the rule of law, as I have stated earlier, is a function of the Constitution, function of the law, taking into consideration what remedies, what redress, and what options are available for you in law. Provided your actions are rooted in law, and they are never arbitrary, and think the clear position is you are operating within the context of the rule of law. More so when a public interest is an issue and then individual interest is an issue, the responsibility of the Office of the Attorney General is to ensure that the public interest upholds. So I think that sets the record clear as far as the function of the rule of law is concerned, and we shall continue as a government to operate within that context, the context of taking advantage of what options, what redress, what remedy is available to us as a government within the context of the Constitution and existing prevailing legislations. And I think the rule of law, it is about law, and if the law or legislation provides that you have certain options and then you now take advantage of those options, you can never be adjudged as being operating in arbitrary. You can never be charged of operating arbitrarily. So I think the function of the rule of law is indeed the function of law. Is there a law in existence that support what you are doing? If the answer is yes, then certainly, and there are no two ways about it, you are operating within the context of the rule of law. The issue is when you decide to resort to self-help, when you decide to overlook the prevailing legislative options, redresses, and remedies available to you. If your remedies are rooted in law, and you are pursuing a remedy within the context of the law, you are operating within the context of the rule of law and not otherwise.
And the reforms at the EFCC. What is the future of the EFCC?
Well, you see, institutions generally are functions of law. EFCC was established by law, and within the context of the law, EFCC operates, or is supposed to operate. So with that in mind, I think there is no room or no place for the Attorney General to unilaterally, exclusively, without recourse to the legislature, without amendment to the prevailing rule of law, to take a decisive position. It is a function of law and legislation. Our Office of the Attorney General is not, does not have the function of lawmaking. Lawmaking is indeed an art and exclusive preserve of the National Assembly. I am not in a position to state outrightly, or perhaps to answer yes or no, taking into consideration that the function of amendment, the function of reform associated with the EFCC is indeed a function of law. And with that in mind, I will leave that question perhaps for the consideration of the National Assembly. If you feel strongly about, I suggest that you please pass it on to the National Assembly for proper answer. The Office of the Attorney General and indeed Abubakar Malami do not have a ready-made answer for it, because whatever answer perhaps I put across will be preemptive of the functions of the National Assembly. Thank you.
All right, thank you so much. I'd like to say a big thank you to you for spending your time with us this morning. Thanks so much for the insight you've given on the P&ID case and the rule of law in Nigeria.
Well, thank you, AGF Malami, and we wish you all the best at today's FEC meeting. And as you take the next steps on P&ID and other issues of public interest and national interest.